For joining us today. We have a great program, and we're going to get started now. If you do have questions, please use the chat or Q&A feature that some of you have already discovered, and we'll get to them as we proceed through the program. Welcome to today's one-hour interactive webinar, Getting Paid for Your Work as an Expert Witness. During this professional development webinar, our presenters will address challenges facing expert witnesses as they seek payment for their services. Our presenters will discuss what fee structure works best for you, what work or services you can charge for, how to set your fee, and how to deal with late payment. Our presenters for today's webinar are Craig Heidemann and Nathan Duncan. Mr. Heidemann is a shareholder at Douglas, Haun Heidemann. His practice is limited to serious personal injury claims, wrongful death, class action, civil rights, pharmaceutical product liability, felony and misdemeanor criminal defense. Throughout his practice, Mr. Heidemann has recovered significant dollar settlements and judgments for his clients. Mr. Duncan is an associate at Douglas, Haun Heidemann. He attended law school at the University of Missouri-Columbia, where he earned his JD degree in 2007. Nathan is a member of the 30th Judicial Circuit Bar Association and the Missouri Bar. He's admitted to practice before the U.S. District Court, Western District of Missouri. This is the second part of a 10-part professional development series that the TASA Group will be offering experts in 2010. We hope that you find these one-hour interactive sessions as rewarding as we do. If you missed any of these and would like to get an archived recording of previous webinars, they're posted in the Knowledge Center of TASAnet.com. As I said, we will be taking breaks for questions, 2 breaks during the presentation. Please use the chat or Q&A feature, which is located on the right-hand side of the screen, to submit your questions to me, who will then submit them to the presenters. That being said, I am now going to turn over the presentation to Craig and Nathan. Craig and Nathan, it is all yours.
Thanks, Matt. Appreciate the kind words and the introduction. We're excited today to get started talking about expert witness fees, getting paid for your work as an expert. Before today, we did a little informal research. There's a lot of surveys that have looked at what experts are being paid, and some of the trends in how they go about getting paid. So some of the interesting things that we noted: a lot of experts are having collection problems. Only about 20% of the people that were surveyed said that they had not had any problems getting paid over a period of 2 years. So if you find that you're having trouble getting the cash flow coming in, you're not alone. Similarly, there were about 20% of people surveyed that were currently involved in the fee dispute, and then the numbers went up. I think it was 30, and then maybe up to another 30% that had been involved in a fee dispute very recently, within about a year before that. We're going to be encouraging you to use written fee agreements with your experts, or with your attorneys, but the agreements don't prevent problems. The surveys across the board say just because you have a written agreement doesn't mean that there aren't going to be fee disputes down the road. So they're not a panacea for all possible problems that might come up in the fee arena. And one of the most interesting things that we noted was that some of the less experienced experts are charging more than their more experienced counterparts are. I think the demographic was those with about 1 to 5 years of experience for some were charging more than those that were working in that 6 to 10 year range that had been working as experts. There's a number of economic factors that we just talked about that go into how much you can charge, but if you're good at what you do, there's a marketing rule that suggests if you want to make more money, raise your rates. You might do a little less work, but be paid more for the work that you do, and overall, you might find that you're ahead of the game. So just to give you a sense where we're headed today, we're going to talk first about the different types of fee structures that are out there that you can consider as you're setting your fee. We'll talk about specifically what goes into a fee agreement, the benefits of using a fee agreement.
how you can go about getting paid if, for some reason, your hiring lawyer has chosen not to pay you for your work. We'll talk about how you can use a retainer to prevent some of the problems you face, how you go about setting your fees, and what exactly you can be paid for as an expert witness.
All right. Well, you know, you're going to hear us, if you tuned in to some of our earlier webinars, we stress communication. We sound like the broken record. But communicating with your hiring attorney throughout your relationship with them in a case is just paramount to avoiding problems, to doing good work, to maintaining a sterling reputation. So this communication concept is just very, very important.
So there are three typical types of fee structures that are available to you as an expert witness. First and the most common is just a straight hourly fee structure where you are paid, as it says, a certain amount for each hour of work that you engage in. And by far, this is the most common way that experts work.
It's also common that experts are going to characterize the hourly fee that they're going to charge as it relates to review of documents, report writing time, deposition time, trial time, travel time. So there are many subcategories within the hourly fee arena of different rates that you can charge, and you need to decide what's best for you. Having a flat rate across the board oftentimes isn't going to sit well with a lawyer if you might say, well, my hourly rate is $700 an hour, and I don't care whether I'm driving to a deposition or whether or not I'm testifying at trial or writing a report. I think you're going to be more marketable if you break that down into smaller, easily digestible units.
And can justify why you have
Sure.
you varied your hourly fee.
The next one on the list is one of my favorites, Nathan, the flat fee. I love experts that charge flat fees. That way I know if I send them, 3 boxes of documents to review before writing a report, I know how much it's going to cost. I don't have to gamble on whether or not they're a fast reader or a slow reader. I can budget and I can decide how much I want to invest in a case based on the flat fee that I contract to pay.
Well, the other great thing for us as lawyers when we hire an expert witness with a flat fee is we can tell our clients up front, this is what you will be paying for your expert witness. Our clients are always asking, what am I going to be paying for this? What am I going to be paying for this? And this is one of those places that we have control where we can explain, we know for sure that you will pay X expert, shouldn't use the same letter, I guess, this expert A, you'll be paying him $5,000, and that is it.
And a lot of experts don't think about that, but the client is your client. Our client is your client. I am an agent for my client in a lawsuit, whether it be a plaintiff or a defendant, but I am the intermediary that helps that client connect with experts who offer their services to that client on a case. Now, in some cases, depending on the contract, the lawyer can become the client, but ultimately the client, plaintiff or defendant, is the one that's responsible for the bill.
The third type we put on here is a hybrid fee structure. Now, I think the most obvious form of this is where you as an expert require a retainer up front before you as an expert begin your work, and where that retainer is non-refundable. So if you're billing against this retainer and you do 5 hours of work, the case settles early on, but you've agreed with the lawyer that the retainer, the $5,000 or whatever it is up front, is non-refundable. That would be, the approach a flat fee, yet you're also billing against it hourly. So that would be one way that you as an expert could protect yourself to make sure you're getting your money for your time on the case.
In no event should your fee ever be contingent. Now, contingent means that you will be paid a percentage of the ultimate result that a client receives. You can't say, I want to take a financial interest in the underlying dispute or litigation. It is permissible, although sometimes unadvisable, to say, I will wait to be paid until the end of the case. I will take my money from your settlement after you settle the case or after it's adjudicated. But that leaves you open, I think, to some credibility attacks, and that you really want the plaintiff to be successful. It puts you more in an advocate role rather than an objective observer role. So although waiting to be paid is not unethical, it's not illegal in many cases, I'm not a huge fan of it. I think if you can afford, if the attorney can afford to hire you, then they need to pay you as you go, and you shouldn't wait to be paid from a pot of settlement money or a judgment at the end of the day.
I saw, Craig, an interesting story about a lawyer that aired on two ways, I guess. First, the expert was basing his opinion, he was using a contingent fee structure. And I think the story said it was a very, very large amount of money that over the years he had collected using this system. This was discovered, he was asked about it, and under oath, rather than telling the truth, he said he did not use the contingent fee structure, and he was recently sentenced, I believe, for perjury.
So did not end well for that expert. All the more reason not to use contingent fees.
And I suppose if you must, tell the truth about it.
Fee agreements. We're a big fan of fee agreements. It's part of that open communication about what to expect, what lawyers should expect in their relationship with you. And surveys show that over 46% of expert witnesses actually require a fee agreement before jumping into a case.
And hopefully at the end of our webinar today, 100% of you will see how useful they are and decide to use these in your practice.
Because the statistics say that 50% of the folks that are with us today, we're up to 61 right now, 30 of you, and you know who you are, aren't using expert witness fee agreements. So we're going to post a couple of them, or we're going to send them out after the seminar or put them online. You'll get access to them. And if you're not using one, we'll put some sample ones out there for you to take a look at and consider using.
The important thing to remember when you use a fee agreement is it needs to be a contract. So we might refer to it as a fee contract just to emphasize it. But like we mentioned earlier, just because you have a fee contract in place with a lawyer, that doesn't guarantee that you'll be paid. What it does is it makes it easier down the road should the hiring lawyer not pay you. It makes enforcement and collection a lot easier.
From a contractual point of view, and I'm going to say this twice because it's important, sending your fee schedule and your CV to a lawyer and then doing work for him afterwards is not a contract. That in no way guarantees, in most of the states that I'm aware of, that you're going to have a contractual right to be paid the amount in your fee statement for the work that you do. You may have other rights to be paid on a reasonable basis test, but unless you have something signed by or some indicia that there's a meeting of the minds or an agreement about what work was going to be done and who was going to do it and what you were going to be paid for it, you don't have a contract, so we need to make it a contract.
And there's two ways that I thought of that you could go about doing this. You could have two separate documents. You could have a retainer document, and you could have a fee contract that's a separate document. Require the hiring attorney's signature on each of those separately, or you could have a retainer agreement that talks about what you're being hired to do, those expectations, and then you might attach your fee agreement as an exhibit to that retainer agreement, and it's called incorporating it by reference, where you say we've adopted. We also have this fee agreement, this fee schedule. And we're incorporating it.
And this is why it's important, and I'm going to, at the risk of jumping ahead a little bit, when we have a written fee agreement, we can include language in there for all eventualities. Let's say that you have a fee dispute and you need to go litigate against the lawyer that hired you, and he lives in Washington State, and you live in South Florida. You're probably going to have to sue him in Washington State to get jurisdiction. You can't afford to travel for a $5,000 unpaid bill, or maybe even a $10,000 unpaid bill up to give depositions and testify in Washington State. But if you have the written fee agreement, and it says, if a collection dispute arises, and if I prevail, you're going to pay my attorney's fees, you're going to pay my travel fees. If I have to travel up for trial, I only stay at the Four Seasons, I only rent a full-size luxury car, and all of these things now become the contractual obligation of the attorney that doesn't pay you if you have to get sideways with them and litigate down the road. We want to avoid that, but you need to plan peace through war, Pax Parabellum. You plan for the worst, hope for the best.
Well, not only, saying that they would have to repay you for your expenses and your attorney's fees, I mean, you could set forth in your fee agreement that if there is a collection dispute, it will be litigated in a certain county in a certain state where you reside. It would make it easier
if
for you.
If you don't have that, you've got that travel issue where, they hired you. They didn't come down to South Florida to hire you. You contacted them, or they contacted you on the phone. So unless you have a written agreement with a forum selection clause, the fallback provision is you've got to sue them in their home jurisdiction.
So there are a few things that you should just always have in your fee contracts. The first thing we thought of, obviously, is if you're charging an hourly fee, you need to include what those hourly rates are, and for each item. If you're charging a retainer, an upfront retainer, you need to set forth exactly what that amount is, whether it's refundable or not, and yeah.
You need to decide who and how the billing is going to take place. If the hiring attorney is working on behalf of an insurance company, you might be submitting your bills directly to the insurance provider to be paid. If you're working for private counsel, obviously you're going to be billing them, but you need to know who and how often you're going to be billed. A lot of insurance companies these days are only paying bi-monthly, or some are even paying quarterly. So if you don't know who really is paying the bill, you may think, I'm going to send out my bill at the end of February, and I'll be paid, 15, 20 days into March, and the attorney tells you down the road, no, XYZ insurance company is paying for your fees, and they only pay quarterly. You may not want to take that case, so you need to figure out up front who you're going to bill.
And if you have this fee agreement in place and the attorney sees that you expect to be paid monthly, and he or she knows that the insurance company doesn't pay monthly, that's something that you and the hiring attorney can work out before that agreement is signed and before the first payment comes due. So it deals with that problem up front. Another thing you could set forth is what services you will specifically provide.
That's like buying a car. You might have a Pinto, you might have an Infinity. There's a number of different ways that you can approach a problem. And if the lawyer only wants a Pinto and you're willing to give him a Pinto, you need to make sure that you've limited the scope of your work in your fee agreement so that there's no misunderstanding about the issues that you're considered.
So he's not paying Pinto money for a Mercedes-Benz.
Can't have champagne on a beer budget.
Right. All right. If you have a specific procedure for being paid for deposition, trial, or some other hearings you might attend, for example, if you require that you're paid up front and you have money in your hand before you answer the very first question, make sure you say that in your fee agreement.
We had that come up this past week, the week before that, and had an expert in South Florida, and he wasn't going to give his deposition to the other side until he had his money, and they didn't realize that, and so rather than attending by video conference, they got on a plane and they took him his check.
The check had a personal escort to West Palm Beach.
All right, let's see what we got. Forms of payment. I mean, if you only want cash, if you don't want to take credit cards and pay, a bank a fee for that, you need to specify that in the fee agreement as well.
One of our participants asked specifically, our thoughts on experts being paid by credit card. And really, that's something that's up to you. I mean, if you don't like being paid by credit card because of the fees and some of the problems that come with that, you can say, I only want cash or cashier's checks or something like that. But if you're okay with the credit card, there's nothing that would prevent you from doing that.
I don't know, Nathan. The bank's already got my bailout money. They don't need any more credit card fees from my clients. All right, what do we have next? Cancellation policy. A lot of times expert witness depositions will be scheduled. You'll set aside a day to give an 8-hour deposition, and then all of a sudden you'll get notified a day or two beforehand, hey, no deposition. We just can't make it. We're either canceling it or postponing it, and you're left with no patients that day. 45% of our experts that are on the phone today are healthcare experts. Maybe you've canceled your clinical your clinical visits that day. What are you going to do? You need to have a cancellation policy with clear direction on who's going to be responsible for it.
And the timetable for that. If it's okay with you that you only, 48 hours notice is enough for you to deal with that time, make sure you mention
maybe you charge half rate if it's canceled inside of 48 hours. It needs to be reasonable, but you need to have it in writing.
The next thing is what happens in the event that you're not paid. Craig touched on this. You know, if you're not paid, what are the parties going to do? You know, the specific things that we mentioned, you want them to pay for any attorney's fees that you have to pay, any cost of collection you have to pay as a result of their non-payment. Interest, what you might charge on outstanding balances.
Here's something that you probably haven't thought of as a cost of collection. Normally, expert witness fees are not taxable as court costs, but if a dispute arises as to the reasonableness of your fee, and that's probably a common problem that comes up, we may need, if I were representing you in collecting your fee, we may need another expert to get on the stand and testify this is a reasonable fee for the scope and the difficulty of the work performed. So we need to include in our cost of collection that it specifically includes expert witness fees, because costs, and I'm putting that in quotation marks, in federal court and in many state courts does not include expert witness fees.
So this would guarantee that they would pay your, if you have to hire somebody to testify about your fees, would make sure that you're repaid for that. Other things, any expenses, if you have specific expenses that would not be included in your hourly rate, you need to specifically list what those might be and how you're going to charge for those. If you're paying out-of-pocket and there's a certain percentage that you'll charge on top of any out-of-pocket payments you make, you need to set that forth in the fee agreement.
You know, for instance, those expenses might include mileage, they might include
airfare,
hotels. Maybe if you have to prepare a trial exhibit and you're going to mark up what it costs you to prepare the trial exhibits, that should be in there as well. We should probably also indicate whether or not we're going to charge for phone calls and how much per minute. If any photographs are going to have to be generated, how much we'll charge for those, and other things.
I mean, frankly, the more specific you are on these, the better. I mean, I think it's probably it is difficult to outline every single expense that you might incur as you go through this. But like we said before, the more that I as an attorney know that I will be, the more certainty I have about what I will be charged for, it's easier for me to budget and deal with those ahead of time rather than when I get the bill for those.
Sure. A common issue that will come up after, where we don't have a fee agreement, is you have an expert that wants to charge you portal to portal. And that's common. 86% of most experts are going to charge portal to portal. But you need to have that in your fee agreement so that there's no question. 10% of you on the phone today will only fly first class or business class. If that's a requirement, you need to have that in your fee agreement, because I think that if you have anything unique about the way that you like to travel or the way that you like to charge.
The hotels you like to stay at.
The hotels that you like to stay at. You don't want to leave it to the attorney to put you up at the Motel 6 if you prefer to stay at the Ritz-Carlton.
All right, then the other thing, like we talked about, you want this to be a contract, so you want signatures from the attorney who's hiring you and your signature to show that there has been an agreement, that everybody is signing off on what's contained in your fee contract.
Now we've made the attorney and his law firm the client. By them signing it, they become the one that's responsible for your bill.
All right. So those are very specific things. If you include all of these things in your fee contracts, you'll be in a much better position down the road if there's a dispute about what you're to be paid, to get your money.
We're going to be heading into a Q&A section in a little bit, so now's a good time to type in your questions and get those headed this way. We've got a list that's piling up, and we've got an opportunity to answer some more, so if you have any questions, go ahead and start typing those in now.
Let's talk a little bit how specifically you can go about collecting fees. And by virtue of you being here on the webinar today, you're in a good position to get your money. TASA, it's our understanding, is part of your relationship with TASA. TASA is the one that will help you collect your fees in the event of non-payment.
You won't be on your own trying to decide the best way to collect your fee. You've got a larger organization with experience, and resources to make sure that you get paid for the work that you've completed. So take advantage of that. If you've got opportunities to send hiring attorneys via TASA to retain you, I'd say, the opportunity to have them handle the collection dispute is well worth it, and we'd encourage you to do that.
To the extent, though, that you do work aside from your work with TASA, you're obviously going to run into a situation where you may have to collect. I guess the gatekeeper for that is, I guess one thing that we want to emphasize is don't wait to start trying to collect your fees. If an attorney is late or has not paid you, don't keep putting off trying to get your money.
Nobody likes to talk about money, but talking about it prevents further problems, prevents the worsening of the problem. So if you know that an invoice is 30 days late, you need to be sending out a collection letter.
And make it your standard practice. Just when it happens, and that will soften the blow, I guess, to some extent to the person who isn't paying. You say, look, this is just my standard practice. Whenever it's 30 days late, I send this letter out. And by doing that, there's not this impression from the attorney not paying you that there's some kind of leeway.
The 3 L's, and let's hopefully avoid them all: letters, lawyers, and lawsuits. Sending the collection letter is useful. It often would precede having perhaps a lawyer get involved and send another collection letter. And then finally, the filing of a lawsuit would be the culmination of your collection attempts.
And you're entitled to do these things, but our point is avoid them at all costs because they take a lot of time. They can be very expensive,
very distracting,
and will take time away not only from your work as an expert witness, but if you're a doctor or some kind of an engineer that has another business, another practice, it's taking time away from that as well. So the easiest way to avoid that is by getting paid up front,
either with a flat fee, refundable retainer, non-refundable retainer, or a combination thereof. The surveys have shown that experts that charge up front, maybe for 5 days of work, whatever you charge for a day of work, you multiply it by 5. They have a good track record of getting paid after the scope of that work is exceeded. And the more days up front that you require, the more likely it is you're not going to have collection problems in the future.
In fact, one of our participants emailed ahead of time and said, I make it my practice to charge up front, and I rarely, if ever, have any problems collecting.
Good for you.
Exactly. It's a good practice, and we use that in our law practice. We feel that there's a risk of not being paid by a client. We require an upfront payment as well. Let's jump into a little Q&A, Greg.
All right. Well, we talked about how somebody asked, how long should an invoice remain unpaid before asking why it's late? I would say no more than 30 days. Net 30 is a common term of payment. I'd say, on the 30th day, I'd have my letter going out. I'd make it my routine practice. Another question we had is, is it acceptable to insist on having perhaps a credit card on file that if the invoice is more than 30 days late, you're authorized to charge that card? That's an insurance policy. That's a good way to think about that.
Ann Reich, she asks, I successfully used a retention agreement for the past 2 years with my clients. What's the best way to incorporate these terms to bind an attorney-client when working through a third party such as TASA or like organization? We were chatting with Matt before the webinar. It's our understanding that TASA uses a memorandum of something that starts with confirmation. Thank you, Matt. A memorandum of confirmation that kind of embodies the terms of what your fee structure is. But there's nothing that TASA has no objection to having a specific agreement in place with the hiring attorney that sets forth all of these things that we talked about today.
TASA's not going to state that you'll only travel first class. If you're going to make those arrangements with your hiring lawyer, you're going to need to have those in a separate fee agreement incorporating your TASA hourly rate or fee that you've got through the organization, and so you need to pin that down yourself.
But these particulars, those could be contained in the memorandum of confirmation. We've had a couple people ask about how to calculate the upfront payment or even the flat fee. Kind of the standard or a common amount on a retainer, if you're going to require that, in average would be about $1,500. But for each of you, you all do different work. The amount of time, how fast you work is different. I would say if you're thinking about using a flat fee structure, you would look at kind of a rough estimate of what you would anticipate it would take time-wise to complete the work on the case, and then multiply that by an hourly rate that you feel fairly compensates you for your time.
You know, somebody had asked, if you charge a flat fee, what happens if you have to do more work than you thought you might have to do? Well, that's the very nature of flat fees. Sometimes you have to do less. It's an average. And I've got one of our experts that we like very much, his fee and expense policies, and he talks about that. He says, and I'm just going to quote from it, he uses a flat fee formula for professional services, and his practice is, once he's requested to participate, he requires a remittance of a $7,500 case preparation fee. The sum covers in its entirety whatever research, analysis, and preparation I may have to engage in to effectively prepare for trial. While this figure is based upon an estimate of the average amount of time consumed by the majority of cases, no additional fees will accrue should your particular case require a substantially greater amount of professional time. And you know what? I like that. It's a little bit more than the average retainer that's paid is about $5,000. The average expert in the United States for his work on the case makes slightly more than $10,000. So this expert, in calling it a flat fee, he's effectively getting 3/4 of the average expert witness fee paid nationally up front 100% of the time before he even looks at the first document.
And he also charges, on top of that $7,500, he has a flat fee for court appearances and depositions. So I think it's $2,500 for each of those appearances. So he's made sure that on top of the time for the for the case preparation and that sort of thing, he's also being paid for his time testifying.
You know, as far as how much you should set your retainer agreement for, if you don't want to use an hourly rate, I think you need to decide within your field of expertise how many average days you work on a particular issue for the lawyers that you work for, and use a day rate. You know, I'm going to charge my day rate times 3 as my retainer, or my day rate times 5. Remembering that statistically, the more days you bill in advance, the fewer collection problems you're going to have.
Somebody asked about raising your hourly rates after you've already worked with another attorney, with one attorney.
Well, the flat fee expert, he raised his rates 2 years ago, and let me tell you how he did that. He said, my rates used to be this, but I've installed a video conference system so that you can video conference with me in high def, 24 hours a day, 7 days a week, and I've gotten a new cell phone that tells you my GPS location. I mean, he added some value back, and he raised his rates $2,500.
And, you know, these hiring, it may be uncomfortable to talk about, but I don't think you're going to get a whole lot of pushback because, I mean, as attorneys, we periodically raise our rates as well.
We have to.
You have to. It's just a cost of doing business. Things get more expensive as time goes on. So just be upfront and open with the hiring attorney.
All right. Speaking of pushback, we had a question. I'll go up here, Nathan, so I can read that. Alan Werner had asked, what do you suggest if the attorney or insurance company pushes back on specific items in the fee agreement? Well, it's all a negotiation, but I've found one of the reasons that I don't work with direct pay insurance companies anymore is they just flat out refuse. And if you don't want to accede to their demands, they'll go find somebody else to do the work, or tell their attorney to go find somebody else to do the work. So I mean, I think everything is negotiable. I think it merits talking about it, but I don't think you're going to be very successful, especially on the quarterly billing, which I think is just ridiculous.
William Berglund, he asked about how to charge for travel time, and we touched on that earlier, but he says he usually charges half of his standard rate, which is perfectly fine if that works for him. Some experts say, you know, whether I'm sitting in my car or I'm doing other kind of work, I'm taking away from my time doing something else, and that is worth X amount of dollars.
If you can explain it, you can charge it.
And you will have to explain it. We talked about that last time, but just decide on an amount that works for you. And one of the kind of an underlying theme here is it's very flexible. It's whatever works for you. And as long as you can explain it and it works out to the satisfaction of the other party to your retention contract.
Okay, a couple more questions, and then we'll dive back in. Let's see here. Okay, here we go. Paul White asks, when my deposition is taken, I'm paid in advance for the amount of time opposing counsel thinks the deposition will take. What happens if opposing counsel runs over and I haven't been paid? Can I stop the deposition until I'm paid? What are my rights, considering I'm there due to being noticed or subpoenaed for deposition? That's a great, great question. Generally, once your deposition commences, you have the right to suspend it if you want to seek a protective order with the court. Now, let's pretend we're in federal court. But if you stop the deposition to go ask the court to intervene, maybe the money's run out of your meter, and the judge says, no, you should have continued, you can be responsible for the other folks' attorney fees and expenses in defending that motion and reconvening it. I liked the day rate. I think a lot of lawyers, you charge a day rate. We had an expert down in Texas say, look, the reason I don't care if you want to depose me for an hour or 8 hours, I'm charging you all day because my experience is lawyers talk too much. They can't effectively estimate time. It always runs over. I can't see any other patients. So I set aside a whole day, and you're going to pay me $2,900 to get my deposition. And that's just the way it is. And I think, you know, that's commercially reasonable.
Vanita, it looks like, asks if fixed fees for initial consultations are common practice among expert witnesses. And I think that's perfectly acceptable. I know there's a lot of experts that do charge that. You know, if I want to get just a general feel for what my case is about and whether I have a chance, I'd be perfectly fine with paying somebody for their time on the phone.
You know, and let's think about that. If you're going to do an initial, I'll call it a smell test on a medical negligence case, you're going to need, and let's say it was a surgical mishap, you know, you're going to need an admit note, a surgical report, a discharge diagnosis, maybe an autopsy report. I don't know. You're going to need to speak with the attorney a little bit on the phone. You can estimate about how much time that would take for an average case, and you could set a fixed fee for an initial evaluation. It wouldn't include any report writing. It wouldn't include any follow-on, but you know, that way you don't have to bill the attorney for going and looking at a medical journal or reading a peer-reviewed article or something like that. One more,
and this kind of heads us into the next topic. William Berglund asks, should you begin working even though you haven't received the agreed-upon retainer? I will tell you that our practice here at the firm on cases where we require a retainer is that we do not start working until we get the money up front.
No pay, no play.
No play, exactly. So let's talk, Craig, a little bit about retainers. That's an awful picture, and it's fairly cheesy, but I just couldn't resist.
Shameless.
All right, so what's a retainer? Basically, you're getting cash up front. The practice is as you work, as you do the work, you bill directly to the retainer rather than sending an invoice to the client.
A couple of points on that. As you're billing to the retainer, you may not use it all up in a month. Every month, though, experts, I encourage you, send out statements. It's a method to communicate with your client. It lets them know if you've done work. It lets them know that you're alive. It lets them know how much money they have left. That way, if you have used it up or if you're going to use it up, when you go back to the well to get some more retainer from your lawyer, he's not surprised. He knows that you've been working on the case. He knows what you're doing for him to help him gather information and form opinions to work on the case. So sending out that statement is super important.
You have a choice whether to make it refundable or non-refundable. We've touched on that earlier. Obviously, if there's money left in the account or from the retainer at the conclusion of the case, if it's refundable, give it back. So I mentioned here additional retainer. I think a few people asked this question. I've seen it on a handful of retainer contracts, fee contracts from experts where once that initial retainer has been exhausted, it is perfectly acceptable for you as an expert witness to require an additional retainer to make sure that you are paid, especially where there's a risk that the lawyer is not going to is a no-pay risk, I guess.
make sure that you ask for the additional retainer before you squeeze out the last drop of the retainer that you were initially paid. That way there's no gap. Time, one of the reasons that we encourage experts to charge what they're worth is the time demands that are placed on you. I mean, things that happen in the world of litigation happen at a pace, and you have to keep up with that pace or malpractice occurs. And so to keep up with that pace, you charge a premium. So making sure that there's always gas in the tank allows you to keep up with the pace. If all of us, because if it's an attorney that has to go back to the client to get the money, that's going to take some time. It's not going to happen overnight. So make sure that additional retainer is asked for in a timely manner.
And in your fee contract, make sure you say, I may require an additional retainer once this initial retainer may require an additional retainer in the event that the initial retainer is exhausted. That way they know that you might ask for additional money. They're not surprised by it.
All right.
Let's talk about how you go about setting your fees. And this came up a lot. People want to know exactly how do I know as an expert what dollar amount I should charge per hour? And I guess my response is there is no set formula for deciding what that is.
When the attorney calls and asks you, what your fee structure is, I think you should ask him, well, how much money do you have?
Let's not do that. The important thing is, what are your goals? Are you replacing, is this your sole source of income? Is it how much do you require to feed your children and survive? That obviously will affect what you charge. If it's just a hobby, you're trying to supplement some income, that might affect what you charge.
The Colorado Bar has come up with an interprofessional rules of responsibility governing the relationship between lawyers and experts. And if you guys want to check that out, grab a pen and jot down www.cobar.org. the coloradobar.org, and you can search for expert compensation and expert witness fees. And in Section 9.2, they kind of go through a laundry list of about 8 things to consider in what constitutes a fair and reasonable expert witness fees. The amount of time obviously is going to be important. If you're being called on to do piecework for an hour, maybe you're going to charge a little bit more. If you're going to be it's going to be a steady stream of work over the course of a matter of months, maybe you can justify charging a reduced rate. If you're going to have to take away a lot of time from your practice to do the work, then maybe you need to charge even more again.
The other thing to consider is the knowledge, learning, or skill required to render your opinion. If you had to go through several postgraduate work and extensive education and training to render an opinion, then your fee should be adjusted accordingly. Should be higher than somebody who didn't have to go through that same level of education.
If the amount of your fee is directly dependent on how much knowledge, learning, or skill is required, I would have to say, based on my experience, cardiologists are the smartest, most learned, highly skilled healthcare providers on the market because they tend to charge more than, say, an accident reconstructionist might. They're both very important fields of practice, but it obviously it takes more investment to become one than the other.
If you have some trait or some qualification that makes you different from somebody else, that is yet another reason to increase the amount of your hourly rate or your flat fee, however you're going to charge. If you are, if your qualifications are very similar to another, say, engineer working down the road who's also doing expert witness work, it's going to be harder to justify a higher hourly rate than that individual.
And, consider what everybody else is charging, as we said, and then also consider the amount of professional fees that you might lose from your practice having to designate time working on the case.
Or even non-monetary effects that might happen to your practice if you're doing expert witness work.
All right.
Here's just a brief sampling. I think the average fee for expert witnesses that we saw, and this covers anybody from a nurse to an engineer to a
veterinarian,
anything like that, is about $250 to $290. This is just a sampling of some fees that we saw. very few charge less than $100 an hour, but it goes up from there to massive amounts.
Here's one of the more interesting statistics that we came across, and 45% of all expert witnesses that are holding themselves out as offering testimony are in the medical field. Okay, and within that medical field, the average hourly fee of those experts for trial testimony is 124% greater than non-medical experts. So what that says is that, you know, the average trial testimony is $248, but if you're a medical expert, that average trial testimony is like $555 or more. So clearly, medical has a higher weighted percentage for the hourly fee that they're charging than any other field. So it's not, I guess what I mean to say is, if you're an engineer, you might not want to set your benchmark of what you think you're going to charge based upon what the pediatric neonatologist is charging down the street, because it's kind of apples and oranges.
Here's some average rates for specific testimony or work that you do. An average rate for testifying at trial among all experts is about $385. $350 for depositions, $250 otherwise, and the median retainer is about $1,500.
And consider that flat fee concept too, where if you're gonna eat your meal in 6 separate bites to get to your average $10,000 payment, and you can get it, you know, $7,500 up front. The average retainer would say that you know, we're going to get $10,000 on the job, we might as well get it up front. And you can explain that, too, I think, to your hiring lawyer.
Well, and that one that we specifically referenced, the expert that we like to use down in Florida, his fee structure reflects that average. It's $7,500 upfront flat fee and then $2,500 for your deposition. So that's very consistent with what we've been saying. So how do you find out about what these average rates are? TASA is a very useful resource. They can provide information. You can always go to Google.
The surveys that we mentioned, if you Google expert witness fees, you're going to hit on the ones that we're discussing today.
And I'm sure you know people that do similar work, other doctors, other engineers, other veterinarians who do this kind of work. Just talking to them about it would be a way to figure it out. So what, as an expert witness, can you be paid for? The general rule is you can get paid for what you ask for.
If it's related to the case, travel time, overnights, mileage, per diem, out-of-pocket markups, all of the things that we mentioned at the outset that maybe need to be put in your fee agreement, you certainly are entitled to be paid for those things. Just avoid any misunderstanding. If you charge for a cigar every night that you're on the road, make sure that you put that down in writing.
But, I mean, like we say here, the key is to be very specific from the outset so that everybody's on the same page as to what they're going to end up paying down the road. Let's take a few more questions.
All right, we're looking at a question. A lot of problems with fees come up at or near the time of the deposition. Paul White asked again, if your attorney says he's going to get you current on your account, but you all show up for deposition and everybody's gathered and the court reporter's there, what are your alternatives? Well, assuming that you haven't been subpoenaed and you're not subject to the subpoena power of the court, option 1, you can get up and leave. But you have to kind of evaluate your reputation as far as whether, you're going to let money kind of drive you to get up and leave the deposition. You don't know what the attorney might say about that to other folks that might use you. You can obviously put something on the record where you get the attorney to agree on the record that he's going to pay you within 10 days of your deposition. You might ask the court reporter for permission to sign the deposition at the end and then let your hiring attorney know afterwards you're not going to sign the deposition unless and until you're paid, which would make it less useful at trial. But we've found, and I say this very sincerely, the best expert is a happy expert. If you are not happy with your hiring attorney, you're obviously going to offer truthful testimony during any deposition or adjudicative proceeding, but we want our experts to be happy. We want to give them no reason than to do their very, very, very best work.
Gary Farkas, he was asking, he said he was retained on a case to provide some consultation. Ended up that he didn't have to do a whole bunch of work and didn't make very much, even though his expectation, I assume, was that he would make more. He said he thought that maybe the expert or the attorney had hired him and retained him just to prevent the other side from hiring him. He wanted to know how to avoid that. You know, attorneys are devious, I guess, try to conflict somebody out of a case. But, I mean, the best way to do that is, if you're going to charge hourly, require a retainer up front that protects you, you know, for, if he just hired you to sit around and put your name on a paper, you're still going to get paid $1,500, $2,000, whatever that happens to be.
I'd say a hefty retainer will go a long way towards stopping those kinds of shenanigans.
And, I mean, you could put something in your fee contract that, you know, require them to, you know, some, I guess, I mean, the retainer is the safest way to go about preventing that.
I'll tell you, one of our experts has the most interesting comment about collecting debt from attorneys, and he says he includes in his retainer agreement that, he may not put this in his retainer agreement, but he makes it clear, maybe in his collection letter, that he's prepared to report the attorney to the State Bar Association for not paying his expert bills unless he's paid within a certain amount of time. Generally, I think that might be a motivating factor, but here's how I think about ethical complaints. As an attorney, something is either an ethical violation that I'm obligated to report or it isn't, and I try not to use ethical violation reporting as a stick to get anybody to do anything. I'm not saying or judging whether or not that's right or wrong. I think obviously stating the obvious, saying, you know, if I'm not paid, it may become an ethical violation. So I'd like you to cure this before it becomes one. But generally, you don't want to either want to report an ethical violation on an attorney's behalf or not.
Somebody asked on the fee contract, who is the client? Is it always the attorney? Might it also be an insurance company, or, you know, if it's a plaintiff, an individual? Typically, you know, as expert witnesses, your interaction is going to be with the attorney. I think it's best to get the attorney's name and signature on that fee contract. Where, you know, the insurance company is cutting the checks, you might also consider adding their name to your fee contract. But, you know, your first line of defense is going to be a contract with the attorney, and put him or her on the hook.
I agree. You know, something else that we haven't talked about that I might mention as far as rates of fee, how much you can charge for. Flexibility is really an underlying theme that we'd like to make sure we weave into the discussion of fees, and that a lot of experts are willing, at least the surveys say about 27% of them, that might charge a lower fee depending on factors like client's ability to pay, whether or not they like the client, you know, whether or not it's a governmental agency. Some of the responders said they charge governmental agencies more. You know, there's certainly nothing wrong with that. But, you know, you might consider this notion of flexibility in all of your arrangements. Everything can be negotiated, and if you're an expert that likes to stay busy, being flexible is going to make sure that you have a market, you have an ability to be marketable and competitive.
But if you are flexible and you do change things, I mean, be prepared to explain that. You know, we had a case where an expert, a medical examiner that was not a retained expert, she was merely a fact witness. We took her deposition, and she wanted to be paid for her time in the deposition. Well, our response was, we will not pay you. Well, our concern initially was, well, what if she is designated by the other side as an expert witness, what if she gouges us for whatever we owe her down the road, charges a hefty fee? The risk that she would run is, if she has charged a lesser rate before to other lawyers, at deposition, we would then say, well, you charge these lawyers X amount of dollars, why are we getting billed for more?
Consistency is important. I mean, you need to be able to rationalize variations in your fee. If you're going to raise your fee across the board, no problem. If you're going to raise your fee for a particular lawyer because you've dealt with him before and you just don't like being examined by him because he's abusive, he's a bully, I think you can do that too. But if you do that, if he asked you why are you charging me more than the other one, I'd say, well, look, because you yell at me, you scream at me, you don't let me take a break when I need to take a break, you ask me questions that make no sense, and that's why I charge you more. It's more mentally draining on me.
And that attorney will certainly regret having asked you that question, and he will not ask it ever again. He will just write the check.
Because your answer would be, he would be required to read that to the jury, and he doesn't want the jury to know that. So I think as long as you can justify the fees that you're charging, have at it.
Someone asked if anyone ever sues attorneys for their expert witness fees. I would say that happens all the time. The concern that this individual has is that attorneys can tie you as an expert witness up in court forever. The way to protect yourself from that happening is by having a good fee contract in place like we've talked about. If you're afraid of being in court, one of the things you could consider is including an arbitration clause in your fee contract.
Or a mediation
Or
clause.
mediation where before anybody filed suit, everybody would ahead of time agree to participate in a non-court setting where there'd be an informal discussion on how much you might settle for to resolve the dispute.
Excellent question from Peter, who asks, what about charging for time spent increasing my knowledge on a subject matter that I need to learn more about in order to give an opinion? Well, be upfront about it. Talk to your lawyer about it. Don't be like Dr. So-and-so in Dallas, Texas, who charged $7,500 to travel to a medical school library to bone up on some very basic and rudimentary things that a person holding themselves out as a such-and-such expert should have known from the minute they were first hired.
Well, because we're hiring you because you are an expert, and we expect you to already have that knowledge that we're hiring you to do. Aside from running the risk of causing problems with your lawyer, you run the risk of looking less credible at deposition or trial when the attorney says, wait a minute, you didn't know this, you had to go learn this before.
But I'm assuming, that Peter is asking a question about, what's the current state of research on the Human Genome Project as reported in this journal article that you don't regularly subscribe to. Well, obviously you're going to have to go out and see what the current state of the art is on the issue that you're forming an opinion on, and that would be perfectly normal. That you're not going to learn more about a subject that's common knowledge. You're going to go out and gain some specialized knowledge within your field of existing expertise to offer the opinion on. So explain it that way. Just be careful in how you choose your words because, the attorneys speak to us like we're third graders. We don't often know what you need to do in order to do your job. So the more simply you can explain it to us, the less opportunity there is for any misunderstandings.
And in that specific situation, I would expect to be billed for the same rate, as you're reviewing a file, document preparation, that kind of fee. I would expect that would be what I'd be charged.
Dennis makes a good point. This is on a collection question. Is there no recourse in getting a reluctant client to pay? My experience is continued requests to pay don't work. I agree. I think sending out letters, people are either going to pay their bills or they're not. Having a good relationship with you guys as expert witnesses, with a lawyer in your town or your community that you can call on to help you. If I send a collection letter for you as an expert witness, I'm going to include as an attachment to it the lawsuit that I'm going to file against you in 20 days if your check isn't on my desk via Federal Express. And if you don't pay, then we can make a decision. If that check doesn't arrive, then we can decide if we want to follow through on it. But having a lawyer do your collection work, I think, has a little bit more of an air of consequence to it. So maybe it's easy for me to ignore Dennis, but if Dennis's lawyer, Gary Spence, sends me the letter, I might not blow it off.
Or about out of time, just the main points we want to remember. Always, always, always use a fee contract. It will save you a lot of headache down the road when, like Dennis is talking about, where after repeated attempts, the lawyer is not paying you. Get your money up front to avoid headaches. Be flexible. Be willing to make accommodations because that will increase the amount of business that you do as an expert.
And stand by for the broken record. communicate with the lawyer. Keep in touch. Send out monthly statements. If a bill is late, send a reminder letter within 30 days. Keep in communication by email, phone. Talk to them. Let them know you're still alive. Let them know you're still doing work. Let them know if you're running out of money.
We're going to get a couple sample agreements, fee agreements, maybe even, we'll get a couple sample agreements out to TASA. So look for those in the future. We'll be able to access those.
We'll have the slides. The slides will be available for download as well. If you missed anything, you're more than welcome to download those. And we hope that everybody took away 3 or 4 things that can help your work as expert witnesses be a little bit more satisfying, a little bit more rewarding. And on behalf of all of the attorneys that take advantage of all of the hard work that you do, a big thank you. We appreciate it. So back to you, Matt.
Okay, great. Thank you, guys. I thought the presentation was great, and on behalf of everybody who attended, I want to thank you guys for putting together another great presentation. As I said during the introduction, this was the second part of a 10-part series that we'll be doing with Craig and Nathan. The next webinar will occur sometime in March. We're still working on a subject matter for that, but please look for an invitation in your inbox in the next probably week or two, and we'll have the date selected for March, and so we hope you join us for that one. We will be sending out an archive recording link in the next 24 hours to everybody who attended, along with Craig and Nathan's PowerPoint presentation. And hopefully by that time we'll also have some of the sample agreements that we'll be able to send out to you as well. All of the expert webinars are posted in the Knowledge Center of the TASAnet website. And if you have any questions or comments pertaining to this presentation or other presentations, please feel free to email me at mhyde@tasanet.com. We welcome all comments. Other than that, I want to thank everybody who was on the line. I want to thank Craig and Nathan for taking time out of their very busy schedule to give us some firsthand experience on what really goes on between a client and an expert. So I thank you, and I thank everyone for joining us. We look forward to seeing you at future webinars. Thank you.